Hi, this is estate planning lawyer Michael Pevney, and in this video we are going to talk about how you can cut a kid out of your estate plan. But before that, if you are interested in estate planning information, please subscribe to this page, leave a question in the comments section, and I am able to respond to most of those. So let's start with kind of the big picture here, and I'm in California, so I'm talking pursuant to California laws. That's where I'm licensed to practice. So you can basically leave your estate to anybody that you want to, subject to community property rules. So meaning if you earned some of your property or bought a home with a spouse while you were married, yes, the spouse has some rights to that. There's some ways around that, like doing a prenuptial agreement or a post-nup, which is a prenup after the marriage has actually happened. But beyond that, you're not required to leave anything to your kids. Now, if you don't have an estate plan at all, the state is going to impose its own estate plan on you, which is likely going to be leaving some of your separate property to your kids. But when you create an estate plan, you are not legally obligated to leave anything to the kids. And there might be all sorts of reasons that you may or may not want to leave part of your estate or any money to your children. It also, there's no requirement that your children also be treated equally in any way, right? We might want to kind of reward one of the kids for being a caretaker, or a kid took off early in life and maybe they've become estranged from the family for whatever reason. Maybe you want to leave them something, but maybe you want to leave them less than you do the first child. And so kind of how do we do that? Because the goal here is to put your desires, put your goals into play and have them executed in the exact way that you want. So for most of my clients, what we do is we create a trust, a revocable living trust, which is a legal entity that you have complete control over while you're alive, and then after you pass away, it does not have to go through probate. And at the very beginning of the trust, you basically state declarations and your family information. So you state your full name, who you're married to if you are married, and the names of all of your children. Because it's important to lay out your entire family structure, because this is what we want to avoid. Say you have a kid that's a ne'er-do-well and you want to totally cut them out of the will, and you didn't put their name in this initial portion of the trust that has like a family declaration. They can then come and say, and possibly sue and say, hey, listen, my dad forgot to put me in the trust. He might have even forgotten I was alive, but he meant to leave me something. So because he forgot to even mention me in the trust or in the will, I should get a portion of that. So we are totally going to negate this from happening by putting the kid's name in the trust, okay? And then when we put what's going to who, whether it's in trust or outright to somebody, 50% to this kid, 25% to this kid, 25% to this kid, and then nothing. So you put a specific statement in there saying, I have purposely made provisions to leave nothing for this child. So you want to make it very clear that you have not forgotten about this child or this person, and you are specifically and purposefully leaving them nothing. Now, some people like to put in there a reason, because they were no good or because you never had a close relationship with them. That's not really a requirement. Some lawyers think that can lead to even some problems. You want to keep things as kind of objective as possible. This is who I am, this is who my family is, and this is what they're getting. And it's important to be complete about all of this. Some people say, and there's kind of some old wisdom saying that, well, if you have a will, it's important what you can do is just leave the kid $1, right? Because if you leave the kid $1, we know that we're not forgetting about them. We know that we've remembered them, and we're leaving them $1 so they don't have the right to anything else. But at least in some states, that actually gives them more rights, because that makes them a legal beneficiary, and that gives them some more rights to sue just for the mere fact that you left them something, $1, $10, anything. So if you want to cut somebody out of the will, out of the estate plan, it's best to mention that first, that they exist, and then also mention that you're not leaving them anything, and you're specifically doing it on purpose, and that you know that you are doing it. Right? Now, I'm not passing judgment on anybody for whoever they want to leave things to, but frankly, not all children are created equally, and you have different relationships with them, and you have the right to leave your property to who you want to leave it to, and the right to not leave it to somebody if you don't want to leave it to them. So if you've got questions about this or anything else related to estate planning and you live in California, you can set up a time to meet with me for free. The link is in the description page. Follow this page for more estate planning information, and thanks for watching.